I'm going to, I know I'm supposed to talk about the amendment bill and the road traffic amendment bill, but I'm going to go a little bit broader than that. And I'll try and go through as quickly as I can, just to give a kind of bird's eye view of the whole situation that we face with regard to public participation in licensing and control of liquor outlets, and that will become clearer as I go through. So basically, for background, the Constitution calls on all spheres of government to facilitate the participation of the public in matters of governance. And the Municipal Systems Act of 2000 requires local government to develop a culture of municipal governance that complements formal representative government with a system of participatory governance. The National Liquor Act provides for the public to participate in the consideration of applications for registration of manufacturers and distributors of alcohol and other related matters. And the Gauteng Liquor Act, I've just taken this as an example, but this applies pretty much across the board in all provinces, in one form or another, allows any person to lodge an objection to the granting of a liquor license and empowers the board to suspend or withdraw a license, which is the subject of a report, complaint, or objection concerning that particular outlet, which could come from the public. So in other words, what the law is saying is that the public should be able to participate, and as far as alcohol is concerned, they can participate by lodging objections to the granting of a liquor license, and that they can also lay a complaint about a liquor outlet that is not operating properly, and should expect to see action taken by the authorities on the basis of that complaint. So that's the background to where we are. So I'm going to look at two issues here in relation to public participation. One is the right of the public to have a meaningful say over when, where, and how alcohol is sold and consumed in the neighborhoods, and which is partly what IDELA was dealing with. And the second is the voice of the public in the drafting of policies and legislation. So the right to have a say in the licensing and management of the alcohol trade is an unfulfilled commitment in most provinces, because the majority of people are not aware of their rights and how to exercise them, largely because little is done to provide them with access to this information. Provincial liquor authorities either have no websites or have websites which focus on providing information to potential applicants for liquor license, little or no information to the public on their right to object to applications and to report compliance infringements. There are exceptions. Western Cape is a good exception, and even the Eastern Cape, and I think it's happening as a result of Enyobeni, is beginning to introduce new information on their website. Gauteng doesn't even have a website. And the way in which participation is supposed to happen is not done in a way that facilitates public participation, and provincial liquor authorities are under-resourced. So even when complaints are lodged, there's little action taken. So everybody's living in a state of permanent frustration. Anybody who's living near a non-compliant liquor outlet is living in permanent frustration, because there's very little that they can do about it. There are built-in institutional problems. Sorry, I want to just go, built-in institutional problems. Constitutional mandates in respect of licensing and management of liquor outlets. The Constitution says nothing about national mandates related to the alcohol industry, but Schedule 5A of the Constitution says provinces are responsible for liquor licensing, and Schedule 5B gives municipalities control of undertakings that sell liquor to the public. The Constitutional Court in 2000 confirmed the exclusive competence of provinces in respect of retail liquor licensing, which limits the ability of national government to set rules as to how alcohol should be managed in the country. And there's also a little clarity on what exactly Schedule 5B means. Most municipalities don't exercise that mandate anyway. In the Western Cape, they do much more than anywhere else, but again, they seem to focus, from what I can see, largely on fiddling around with the operating hours of liquor outlets, but maybe not much more. There's also uneven intergovernmental cooperation. Provincial governments make their own liquor laws, which vary one from the other. The norms and standards released by the DTI in 2014, signed by all provinces, are largely ignored. Provinces are supposed to take municipal bylaws, zoning regulations, and other local government considerations into account, but they don't. But local government often feels unheard. And provinces, like in the Western Cape, and this was even argued in the case of Enyobeni, although it's not clear whether it was true or not, that provinces issue licenses with stipulated opening and closing times, and in some cases, local government overrides their decision and imposes their own operating hours, usually for longer hours than those allowed by provinces, not shorter. The other systemic challenges are that national liquor legislation is the mandate of the Department of Trade and Industry and Competition. Most liquor authorities fall under provincial departments of economic development, the Western Cape an exception again. So they tend to favor economic over social factors when considering a license application. Addressing alcohol harm in the country is the mandate of the Department of Social Development through the Drug Master Plan and the Central Drug Authority, but they don't make the liquor laws. So the above reality means that economic considerations are generally given precedence over public concerns about alcohol-related harm, which has the consequence of reducing the impact of public participation. And finally, there isn't a whole of government approach to dealing with alcohol-related harm, which just compounds the problem. So public influence over policies and legislation, public participation we all should be able to participate in policy making and drafting of legislation. While departments, Parliament, and the NCOP call for public input, advertising of course for public participation is usually inadequate. It's like hidden away in a corner of a Sunday newspaper. So participation is often very poor. Timelines for participation are usually quite short. So consultations within civil society structures are often cursory in order to meet deadlines. Quite often, public participants at public hearings are in good faith, bussed in with no prior preparation. So many are not even aware of the issues and unable to participate effectively. And public inputs are often ignored, leading to a gradual fall off in interest and participation because people just don't want to waste their time. So let me run through a couple of bills now. So the Road Traffic Amendment Bill was drafted in 2012, with the second version coming out in 2015 and the third in 2020. Firstly, the extended period taken for drafting legislation leads to a fall off in interest for all those, but those who've got a professional or organizational interest in the issue. Public participation was invited by the department, and then a modified version was sent to Parliament. Parliament invited written participation within a period of a month. Some individuals and organizations were invited to give oral submissions. We did. Parliament made its decisions and conveyed these to the department. One decision was to scrap completely the clause calling for a reduction in the blood alcohol concentration level of drivers. That bill is now with the NCOP, which might invite further public inputs. The Control of Marketing of Alcohol Beverages Bill was drafted by the Department of Health in 2012. A leaked copy was published in the press in 2012, sparking a furious debate. Cabinet approved its release for public comment in 2013, was never released to the public. Media reports suggest that Cabinet was divided. Government spokespeople denied this, but in 2020, Bigila Mbalula, who is Minister of Transport, thinks that alcohol advertising probably should be restricted, admitted that in 2013, when he was Minister of Sport, he opposed it. So there isn't, again, a whole of government approach, and public opinion on this bill has never been canvassed, and so it's now been shelved. The Liquor Amendment Bill was drafted in 2016 to give effect to the new liquor policy approved by Cabinet in the same year. It did go through a public participation process in 2016-2017. It was subject to a socio-economic impact assessment in 2017, which concluded that if passed, it would save the country lives and money. But all work halted on it from mid-2017, with no pronouncements on it by the new DTRC minister since his appointment in 2019. Sorry, I just went back there. Let me go back. Sorry, going the wrong way. There we go. All work was halted from mid-2017 with no pronouncement by the new ministers since 2019. calls before and during COVID-19 by civil society for it to be passed have fallen on deaf ears. Ironically, just 2 days ago, there was actually a report in the newspaper quoting the DTIC spokesperson saying it would go to Parliament soon. About an hour ago, I had a conversation with someone from the DTIC, and she confirmed they are working on it, and that some of the problems they're having is getting agreements from other departments where there are overlaps on certain issues. But once again, public participation is very limited. I asked her about that, and she said, well, you know, maybe participation will happen once it goes to Parliament, because I asked her, why are you not engaging with us already? Because we can help. But that's a problem, is that that's not how public participation is viewed, which is a difficulty. So the last one I want to look at is the Basic Education Laws Amendment Bill, which the 2015 version of that called for the banning of alcohol on school premises. However, in 2016, the Western Cape proposed a provincial education bill which would allow alcohol at schools and school functions for fundraising purposes. This was opposed by many, including the Minister of Basic Education. It was nevertheless enacted in November 2018. The minister met with the Western Cape MEC in 2017. And then just after that, the Bella Bill in its original format was released for public comment with a note that prior comments would be taken into consideration. In 2021, a new version of the bill was released, and now it contained the same proposed clauses as those in the Western Cape Bill and Act, calling on schools to be allowed to have alcohol. The minister and the department responded angrily to media reports on the liquor clauses, claiming that people didn't understand it, and that they shouldn't assume that because alcohol be allowed at schools that kids could drink. They're missing completely the point of why people were opposed to having alcohol at schools at all. The Parliament invited public comment on the bill. This is one example where public participation did also have an impact, because we and others suggested that the time for comment was too short. And so instead of being for 1 month, it was extended by 2 months after complaints by the public. There apparently are going to be public hearings in all provinces, but the dates are not yet finalized. So an overview of the passage of the 4 bills is that public participation happened or is happening with 3 of the 4 bills, but the depth of participation is limited, as is the impact. The Bella Bill is going to be interesting because, one, most people the SAAPA SA speaks to don't know about it at all, which is an example of how little communication there is between government and people about these issues. The second thing is that when they hear about it, they are shocked and baffled that the department would even consider allowing alcohol in schools. The question is, will the department and Parliament hear this and respond appropriately? And I guess that goes back to what Adila was saying, is what can we do as civil society to make sure that they do hear us? It is disturbing that public participation in the deliberations around legislation is treated so lightly by government. In the case of the marketing bill, it's bizarre that Cabinet decided it should be released for public comment, and that was just ignored with no reason given. That after a period of quite intense public participation, the Liquor Amendment Bill was put on hold, again with no reason given, and no public response by the department for over 5 years, and that Parliament chose to throw out the blood alcohol concentration level clause in the Road Traffic Amendment Bill, despite the public and the research community suggesting a compromise between the status quo and the proposals in the bill. You know, an additional problem is the amount of money that goes into drafting the policies, drafting the legislation, dragging it out over years and years and years, and then coming up with legislation that the public just don't buy into. Quite often the legislation is just not adhered to because people don't own it. They don't feel like they were part of drafting it. So the conclusion that one has to reach across the board around public participation issues, that it's still an unrealized goal. For some government entities, it really is a tick box malicious compliance process. They have to do it, so they do it. They get a register and they say, we met, we talked to the public, and then they go and do what they want to do anyway. There's very little easy access to information, the logistics of the participation process, and that has to be improved for participation to be far-reaching and inclusive. Adila was talking about the fact that the liquor board said that nobody objected. Well, it's not surprising that nobody objected, because people just are not informed. But we also have a situation where very recently I was involved in a particular case where a liquor outlet that applied for a license in Kensington in Johannesburg was opposed by, I think, more than 10, it attracted more than 10 objections, including one from a joint one from the Kensington ratepayers and SAAPA. And somehow, that was in March, and somehow they have a license. So we are trying to find out what happened here, because, we actually were denied the right to actually take part in a hearing to actually talk about this issue and why we were opposed to them having a license. And I think that the other thing is that government's got to be held accountable for their failure to take public participation and intervention seriously. And I have to say that there is one success story that I was involved in from 2013 to 2017, where the Gauteng government behaved in exactly the same kind of high-handed, arrogant way, and decided to push through a particular set of regulations, despite the fact that we pointed out that by doing so, they were actually going to be denying people the democratic right to object to people who applied for those licenses. They chose to ignore us. We took them to court. Fortunately, we had pro bono lawyers. We took them to court. 4 years later, we won the case. The judge threw it out of court, threw the regulations out of court, saying they were ultra vires and not consistent with the Gauteng Liquor Act. They still haven't fixed the problem, but it is an example of where, if we do intervene in civil society to show, because government has not taken public participation seriously, we can win. So I think it's an important thing to consider in all of these situations. Thank you very much. I hope that wasn't too long.